Hi everyone, I'm Dan Fawcett, a partner in the employment team at Womblebond Dickinson. As you no doubt already know, the government has published its Employment Rights Bill. After 14 years of employment law being relatively quiet, other than the Employment Tribunal fees debacle, we now have a government that looks like it will live up to a promise of being more active in the labour market. The bill itself contains no fewer than 28 reforms, and the government has already launched some consultations on further proposals, so this is not the end of the story. On a recent webinar, we asked our attendees which reforms they thought would have the biggest impact on their business. Perhaps unsurprisingly, the highest response rate was that 44% of attendees were most concerned about day one unfair dismissal rights. However, if the bill comes into force as currently drafted, there are other significant reforms. Employers who make use of zero-hours contracts will need to get to grips with a requirement to offer guaranteed hours after a defined period. Employers will also need to do more when responding to flexible working requests. Collective redundancy consultation processes are likely to be required much more often, as it will be the numbers of the proposed redundancies across a whole business that needs to be assessed, not those in one location. Employees will have new rights to bring discrimination claims if they've been harassed by a third party, and it may become very difficult to forcibly change employees' contracts. Finally, there could be a new regulator with more powers to enforce our existing laws. One recent consultation that is particularly important to highlight is that the government is looking at increasing the cap on the protective award for failure to collectively consult claims. That could go up from 90 days to 180, or we could perhaps end up with no cap at all. It's also considering introducing interim relief for protective award and fire and rehire claims. That could mean employers being asked to pay a dismissed employee's wages between the date of a claim being issued and the final hearing. That consultation closes on the 2nd of December, and employers who have concerns may want to think about trying to influence those proposals. Going back to the bill itself, there is some good news. That is that businesses will have time to prepare, with many of the changes unlikely to come into force until 2026, and day one unfair dismissal rights not likely to come into force until the autumn of 2026. However, it is never too early to start planning and thinking about how you will adjust. We've published a handy fact sheet summarising the main proposals. And if you want to discuss any of this in more detail, please get in touch with your usual WBD contact, and also please look out for further podcasts and briefings as we look at the proposals in more detail.